challenging the Political Parties Amendment Act. It's ongoing right now. Let's just listen in.
The list it has is of political parties. And to our minds, the coalition political party is a sui generis organ. This being the case, the rules of formation of ordinary political parties cannot apply to it. It is for this reason that we do not find any discrimination in the amended section. Section 14A of the Political Parties Act, the first petitioner raised issue with Section 14A on the deemed resignations, claiming that the same violated the members' rights to fair administrative action and fair hearing under Articles 47 and 50 of the Constitution. Counsel for the first petitioner did not, however, submit on this issue, and we assume that he abandoned it. The Solicitor General for the first respondent submitted that Section 14A as amended is in line with Article 103 of the Constitution. He referred to the procedures set out in the said amendment. Despite the issue having been abandoned by the first petitioner, we have considered it. A clear reading of Section 14A, subsection 1 to 6, confirms that any party allegedly deemed to have resigned is given an opportunity to be heard on the issue. The deeming resignation is therefore not automatic. Even where the political party notifies the registrar of the resignation and the registrar is not satisfied that Section 14A, subsection 2, has been complied with, he or she will refer it back to the party for reconsideration. This is not cast in stone. We find no unconstitutionality in Section 14A. Counsel for the second, now we are looking at sections 22 and 31. Counsel for the second to fifth petitioners sought to have Section 22 exempting coalition parties from the requirements of audit declared unconstitutional. However, the provision requiring auditing of accounts by the Auditor General is under Section 31 of the Act, which was amended by deleting subsection 3. Counsel for the first respondent submitted that the deletion of Section 31(3) of the Act was to align the section with Article 2294F of the Constitution, considering the fact that it's only political parties who receive public funds who should be audited. We find this not to be entirely correct because with the new amendment, the constitutional obligation of the Auditor General to audit the accounts of political parties funded through public funds is now lost. The section ought to have been amended to align it to Article 229 of the Constitution. We therefore find that the deletion of Section 31(3) of the Act is in conflict with Article 229 of the Constitution and is therefore unconstitutional. We now move to Section 34. Counsel for the first petitioner submitted that Section 34 of the Impuned Political Parties Act increased powers of the Registrar of Political Parties, namely regulating political party nominations and training of political party election agents, which is the mandate of the IEBC. This, he submits, contravenes Article 88, sub-Article 4 of the Constitution. Counsel for the first respondent argued that the amendment to Section 34 complies with Article 92 of the Constitution and is complementary and is not in contradiction to the functions of the second interested party. In its replying affidavit sworn by Crispin Owie at paragraph 10, the second interested party alluded to usurpation of its power by the first interested party. We have quoted what was stated in that paragraph 10. Counsel for the second interested party did not pursue this line of argument in his written submissions, but only stated that Parliament was not bound to adopt all its submissions. We therefore take it that the argument was abandoned by the second interested party. The functions of IEBC in the conduct of elections have been set out under Article 88(4), which we have cited. The amendment to Section 34, which the petitioners take issue with, reads as follows. We have also quoted that. Counsel for the first petition amendment Section 32 of the Elections Act provides as follows, which we have also quoted. We have carefully considered the submissions, the Constitution, the Elections Act, the Principal Political Parties Act, and the Political Parties Amendment Act as cited above. On the issue of symbols, we do not find any conflict between the roles of IEBC parties. The role of the registrar is limited to only certifying whether the symbol of the independent candidate resembles that of any other political party. The IEBC still retains the power and duty to accept or reject the symbol as set out in Section 32 of the Elections Act, as the same was not amended. Therefore, we do not find any usurpation of the power of IEBC as far as Section 34 FB of the Political Parties Act is concerned. We make a similar finding in regard to amendments in respect to Section 34 DA, FA, FC, and FE. We, however, find that Section 34 FD of the Political Parties Amendment Act is in contravention of Article 88, sub-article 4D and K of the Constitution, which vests the power to regulate political party nominations in the IEBC. Statute cannot purport to bestow the same powers in the Register of Political Parties. That would amount to usurpation of IEBC's constitutional mandate. We declare it unconstitutional. Section 38E, we've set it out here. We have considered this section and do not find any usurpation of IEBC's powers by the Register of the Political Parties. In this new section, all that a political party is required to do is to notify the registrar in writing of all the requirements under the said section. The section does not give the registrar any power to make any decisions in regard to that information. Following receipt of the notification, the registrar only publishes it in its website. Furthermore, Section 27 of the Elections Act provides that nomination rules are submitted to the IEBC and not the registrar. This confirms that the powers of the IEBC have not been affected and have therefore not been usurped by the Register of Political Parties. Section 43. It was the petitioner's submission that the above impugned section was discriminatory in as much as the coalition political party is not subject to the Political Parties Dispute Tribunal. In their argument, they referred to the impugned Section 43 of the Political Parties Act, which reads as follows: a coalition agreement shall provide for internal dispute resolution mechanism. It is our finding that nowhere in the impugned amendment does the Act exempt a coalition political party from the jurisdiction of the Political Parties Disputes Tribunal. A political party is defined to include a coalition political party. Hence, a dispute between a political party and a coalition political party is deemed to be a dispute between political parties under Section 41C of the Act. It is therefore deemed to be a dispute subject to trial by the tribunal. We therefore find that the plea by the petitioners in respect of that amendment cannot stand. Section 41(2). The first and second to fifth petitioners raised issue with the above section. They claim that the amendment to Section 41 of the Act is unconstitutional as it denies disputants the right of appeal to the Supreme Court. We do not agree with them on this because the right of appeal to the Supreme Court is not automatic, as can be seen from the provisions of Article 163, Article 4 of the Constitution. We have set that out. See also Section 15, 1 and 16 of the Supreme Court of Kenya Act. The Supreme Court has pronounced itself in the case of Kenya Commercial Bank versus Mwiri Coffee Estate Limited on this issue. We therefore find nothing unconstitutional about the above section, since the jurisdiction of the Supreme Court of Kenya in hearing appeals is clearly set out in the Constitution and the Supreme Court of Kenya Act. The next issue is discrimination of political parties candidates in view of sections 28(1) and 28(a) of the Elections Act as amended. Counsel for the second and third interested parties argued that this court has dealt with a similar case in the case of Council of Governors and versus Attorney General, which is a judgment in rem, and the issue cannot be litigated before us. However, counsel for the sixth petitioner submitted that the doctrine of res judicata is not applicable, as the sixth petitioner was not a party in the previous case. We have looked at the Elections Act, Section 28(1). We have indicated what it provides. We have also looked at the newly introduced Section 28(a) and find that it does not affect the timelines in the Principal Act. In our understanding, counsel for the sixth petitioner seems to say that the timelines in Section 28(1) of the Elections Act should be aligned to those given to independent candidates in Article 85(1) of the Constitution, so as to give political party candidates more time to hop from one party to another in the event that they lose in the party primaries. This issue was well dealt with in the case of Council of Governors, and we have indicated what Justice Mativo said about this. For the above reasons, we find it impractical for the political party candidates to enjoy the same timelines as independent candidates for the following reasons. One, unlike independent candidates, the party nominations elicit disputes and reasonable time must be allowed for the resolution of these disputes. 2, there must be discipline in political parties' activities. 3, IEBC has a timetable which enables them to work on their activities. For example, printing of ballot papers, undertaking trainings for themselves and even the agents and other officials. So that they must have that time so that they work out their program within it. Accordingly, we find no element of unfair discrimination in the provisions of Section 28(1) and 28A of the Elections Act as alleged by the petitioners. The second issue is on whether the constitutional requirements for public participation were observed prior to the enactment of the impugned enactments. The first, second, and fifth petitioners and the fifth interested party raised the issue of lack of public participation before the amendments were enacted. Their argument was based on 2 fronts. First, that the timelines were too short, and secondly, that Parliament confined submissions of their memoranda to email mode only, that they refused to accept written submissions. They therefore urge this court to nullify the amendments on that ground. Learned Counsel cited a number of decisions on that. Counsel for the respondents and the first to fourth interested parties refuted this claim, arguing that there was sufficient public participation. They also cited a number of authorities. Public participation is enshrined in Articles 10(2)(a) and 232(1)(d) of the Constitution as one of the values and principles of governance. Article 259(1)(a) enjoins this court to interpret the Constitution in a manner that promotes its values, principles, and purposes. We have considered the submissions and read the decisions cited by counsel for the parties. The principles of what would constitute meaningful public participation was settled by the Supreme Court of Kenya in the case of British American Tobacco Kenya versus CS for the Ministry of Health and others. We have also cited what they set down as the principles for public participation. It is upon the above parameters that we shall determine whether any steps were taken before enactment of the impugned amendments, and if so, whether the same satisfied the above guidelines. In the replying affidavit of Anne Nderitu, the Registrar of Political Parties, sworn on 15th of February 2022, she gives a full chronology of the consultative meetings and stakeholder engagements which took place in regard to the election laws. It is clear from the chronology given that the process began way back in 2017 after the general elections of that year. To her affidavit is annexed recommendations and reports of the consultative meetings and stakeholder engagements. We see from her annexure ANN1 that the process began with the formation of a task force comprising government agencies and departments which play a key role in the electoral process. It is also evident that the task force held several consultative meetings with members of the public and civil societies and organized groups from whom they collected views. Photos of the meetings can be seen at page 48 to 54 of her affidavit. At the end of the exercise, the task force prepared its report dated 14th of November 2019, and the report indicates that some of the issues discussed were changes to electoral laws, supervision of party primaries, enforcement of electoral laws and regulations, party governance structures, administration of nomination polls, issuance of nomination certificates and drafting of party lists, funding of political parties primaries, conduct of party primaries, conduct of political party primaries, membership of political parties, conflicting roles of IEBC and Office of the Registrar of Political Parties, timelines, independent candidates, nominations, political parties, disputes tribunal. And after the report, further engagements were held on various dates, which are outlined here, from 2020 to 2021. And this can be found in annexures AN 8 to 14. Annexure 9 reveals that the Secretary Generals of various political parties attended various consultative meetings between 27th to 30th of July 2021, where several resolutions were made. Among them were that a political party shall submit their memorandum to the amendment bill by 9th of August 2021. That the Office of the Registrar of Political Parties shall consider the memoranda under paragraph 1 and proposals made during the meetings of the draft bills subject to the Constitution, attendant laws, domestic jurisprudence, and international best practices for purposes of enhancing the draft bills. It was also resolved that a meeting would be held between the Office of the Registrar of Political Parties, IEBC, and political parties to deliberate on emerging concerns in regards to the 2022 general elections, and that political parties would sensitize parties members and Kenyans on the significance of joining and forming political parties. That political parties shall adopt the legal and operational timelines issued by the Office of the Registrar of Political Parties and the IEBC to enhance timely and effective planning of party activities towards the 2022 general elections. Some of the annexures of the first interested party reveal that some of the petitioners were invited to the meetings. For example, there is a letter dated 28th of September 2020 inviting the second petitioner for a meeting on electoral laws discussion to be held on 5th to 9th of October 2020. The second petitioner received and acknowledged receipt of the invitation on 30th of September 2020. A reminder was sent to the second petitioner by the first interested party requesting them to send the name of a person who would come for the meeting. There is evidence of active involvement of the political parties' liaison committee, who even sent a memoranda, AN 16. There are many other parties who are invited for these meetings and some attended. The stakeholder engagement and consultative meetings gave rise to a bill known as Political Parties Amendment Bill. And after the first reading in the National Assembly on 2nd of December 2021, the bill was placed before JLAC, who placed an advert in the local daily newspaper of 7th December, inviting members of the public for their views on or before 21st of December 2021. That was within 14 days. Mr. Michael Sialai corroborates the dates of the consultative meetings and the areas of discussion as stated by the first interested party. After the expiry of the 14 days, JLAC considered the views from the public and stakeholders and tabled its report before the National Assembly on 22nd of December. The National Assembly discussed the bill, which was passed on 5th January 2022 and transmitted to the Senate on 6th of January 2022. Thereafter, the JLAC of Senate placed an advert in the local daily newspapers on 12th of January. Members of the public were invited to make their presentation on the bill on or before 19th of January. They were invited for public hearing and presentations. Pursuant to the advertisement, the committee received 28 memoranda. And in total, therefore, the number of days within which submissions were to be presented was 21 days. The issue before this court is whether from the above facts there was any meaningful public participation before the enactment of the impugned amendments. Guided by the guidelines set by the Supreme Court of Kenya in the British American case, our answer is in the affirmative. From the above analysis, a number of points have been made very clear, which are as follows. 1. The chronology of meetings and consultations as narrated by the first interested party have not been challenged. Consultative meetings were held since 2017 after the general elections to January 2022. The first interested party invited a good number of participants in good time and even facilitated their attendance. 3. There was clarity of the matters under discussion and resolutions were made. 4. The lists of the invitees and attendants confirm there was inclusivity. On the manner of submissions of memoranda, we note that the National Assembly invited both written and electronic memoranda. On the other hand, the Senate only invited electronic memoranda and called for 2 days for public hearing. That was on 20th and 21st of January. It's within public knowledge that this was during the COVID-19 pandemic, and the Ministry of Health in its protocols had prohibited receipt of hard copies of documents. We take judicial notice of this because even the judiciary was not receiving hard copies of submissions and pleadings which had to be sent electronically or through email. In our conclusion, we find that there was meaningful public participation prior to the enactment of the Impuned Amendment Act. We have also demonstrated that the process of public participation took over 4 years and not the 7 days alleged by counsel for the petitioners. We find, therefore, that the ground of public participation has not been demonstrated. The next issue is whether the Political Parties Amendment Act is ambiguous and certain overboard to warrant the striking out of the Act in its entirety. Learned counsel for the 2nd to 5th petitioners submitted that the introduction of a coalition political party in the Political Parties Act has created vagueness, confusion, and ambiguity in the statute, that this has rendered the Act incoherent and unworkable, requiring unpacking of the language. She contends that this makes the Act unconstitutional, and to support her argument, she relied on 3 cases which we have cited here. In response, the first respondent submitted that contrary to the 2nd to 5th petitioner's assertion, there is no vagueness or incoherence in the said definition. Counsel submitted that there is no justification for the petitioner's assumption that political parties cannot come together on account of a shared ideology. The word vagueness was defined in the case of Osborne versus Canada Treasury, which we have cited here. It states, it was held that vagueness can have constitutional significance, and one such significance is that a law may be so uncertain as to be incapable of being interpreted, so as to constitute any restraint on governmental power. The uncertainty may arise either from generality of the discretion conferred on the donee of the power or from the use of language that is so obscure as to be incapable of interpretation with any degree of precision using the ordinary tools. As we understand it, it is the contention of counsel for the 2nd to 5th petitioners that the amendment of the definition makes the meaning of a political party under the parent act ambiguous, uncertain, and prone to different interpretations. As already observed above, the impugned amendment and creation of the coalition political party does not affect the meaning of political party as stipulated under Article 260 as read with Article 91 of the Constitution. To that extent, we have not found any ambiguity, confusion, or uncertainty as claimed by the said petitioners. Our position is based on the fact that there is a clear distinction between a political party and a coalition political party in both their formation and operation. The amendment clearly shows what the mind of Parliament was on the formation of a political party coalition, on the formation of a political party, a coalition, and a coalition political party. There is no doubt on what Parliament intended. It was further submitted by Council for the second to fifth petitioners that it was improper to make the amendments less than 6 months before the general elections. She urged that the Kriegler report recommended inter alia that no amendments should be made 6 months prior to the date of the general elections. There was no specific response to this by Council for the respondents and interested parties, save for Council for the third interested party, who submitted that there was no evidence to prove any unreliability and incredibility of the election process as claimed. Upon considering the above submissions, we make the following observations. 1. Whereas there is no law in Kenya that bars amendment of the electoral laws within a particular time, and considering the recommendations in the Kriegler report, we must consider the context and the period it took to come up with the recommendations leading to the amendments. 2. The Kriegler recommendation on this issue considered the fact that people needed time to participate in the entire process, to raise any objections, to interact with the changes inter alia. The changes herein were made slightly more than 6 months to the general election, which resonates with the Kriegler recommendation. 3. It has not been demonstrated how the amendments on timelines will affect the elections. In any event, these timelines are meant to enable the political parties, the candidates, and the Independent Electoral Boundaries Commission manage their timetables so as not to affect the election date. 4. We also observe that the interest of an individual or individuals cannot outweigh or override public interest. It is within the public domain that parts of the Principal Political Parties Act, the Political Parties Amendment Act, and the Elections Act in relation to the 9th August 2022 general elections have been implemented. For example, gazettement and swearing of members of the ad hoc political parties dispute tribunal. Many parties have done their primaries and nominations. 5. Council for the second to fifth petitioners is calling on this court to strike out the amendments based on conjecture, hypothesis, and speculation. Our finding, therefore, is that the second to fifth petitioners have failed to prove any vagueness or uncertainty in the impugned amendments, which are very clear on their intent. We find nothing to make us strike out the Political Parties Amendment Act on this ground. Whether the petitioners are entitled to the orders sought. We think we have said enough in respect of the prayers sought by the petitioners, and our findings are as follows. 1. There is no unconstitutionality in the amended sections 2, 4A, 62A, 76, 14A, 22, 34, DA, B, FA, FB, FE, 40, subsection 3, 41, subsection 2 of the Political Parties Amendment Act 2022. 2. There is no unconstitutionality in section 28(1) and 28A of the Elections Act. 3. The deletion of section 31, subsection 3 of the Principal Political Parties Act is unconstitutional. 4. Section 34 FD is unconstitutional, as regulation of political party nominations is the mandate of IEBC and not the Registrar of Political Parties. 5, we find that the public participation that took place before the enactment of the Impuned amendment was consultative, meaningful and reasonable. The amendments cannot therefore be nullified on this ground. 6, the Impuned amendments do not render the principal Political Parties Act ambiguous, uncertain or vague. 7, save for what we have found in respect of sections 31(3) and 34(FD) of the Political Parties Amendment Act 22, the petitions fail and are dismissed. And on costs, we have considered the issue. Costs generally follow the event and are in the discretion of the court. However, in the circumstances of this case, we find the order which commends itself to us to be that each party shall bear its own costs. Those are the orders of the court, and you will give us a bit of time just to do some corrections, typing corrections, before we release the judgment to you.
Members of the court, we thank you for your diligence and planning for midnight of giving us this important judgment in such a short time frame. That is very much appreciated.
Thank you so much for your patience also. Okay. Thank you.
Naam, bila shaka mtazamaji, hapo ni moja kwa moja kutoka mahakama ya Milimani, ambapo jopo la majaji watatu hapo, Justice Hedwin Ongudi ambaye anaongoza kikosi hicho, tuko na Justice Esther Maina, mahakimu Esther Maina na Daniel Ogembo, wamekuwa moja kwa moja kutoka mahakama ya Milimani hapo mtazamaji, kwenye kesi ya vyama vya siasa, kesi ya kupinga sheria hiyo ama mswada wa marekebisho kwenye vyama vya siasa, sheria mtazamaji iliyoidhinishwa rasmi na Rais Uhuru Kenyatta mwezi Januari mwaka huu.